I'm Alex Gupta with UATV. Today I'm speaking with Professor David Crane. He is a professor of international law at Syracuse Law School in New York. Hello, Professor Crane. Welcome to UATV.
It's my pleasure to be with you today.
Ukraine and Russia just concluded their trial at the International Court of Justice in The Hague. Would you be able to explain what this case was about and the arguments presented on each side?
Well, again, as you well know, there are significant issues related to both of the countries. Each have significant geographic and political claims against the territories that they both feel they have sovereignty against. And so the only way to resolve this is not use of force, but obviously doing something related to the law. And going to The Hague is one of the key aspects of this, because, again, this needs to be soberly and carefully considered, not in the emotion of the moment, related to some of the past tragedies and atrocities that are alleged by both sides.
I know Ukraine was seeking provisional measures. Would you be able to explain what are provisional measures and what is the standard for being granted provisional measures? What is the burden of proof?
Well, again, this is a seeking by the Ukraine to lay out and to get parameters related to claims, related to issues related to those claims. And so in a generic sense, that's what the Ukraine seeks related to all of this. Again, at the international level, it's important that that these issues be framed out in four corners so that decisions, then political decisions and other decisions and claims can be made. The standard is not beyond reasonable doubt, of course, but they have to have really a substantial preponderance of facts related to their claims.
So provisional measures are somewhat of a type of injunction.
Well, again, it is a set of procedural decisions made to satisfy whatever the seeking party requires. So I wouldn't call it exactly an injunction, but certainly it sets out what the court would like to see happen on these issues.
Russia's claiming that the court has no jurisdiction. Why wouldn't the court have jurisdiction over this case?
Well, again, that's not an unusual thing for any party that has been taken to a court, is to seek jurisdictional challenges and have whatever the case may be thrown out because of the jurisdiction related to whatever the issue may be. That's up to the court to decide. Certainly, it's a proper argument to be made, but again, it's up to the reviewer.
Isn't it similar, Georgia, when they took Russia to the ICJ, the case was thrown out for jurisdictional issues?
Well, of course, again, the ICJ is going to look at their rules of procedure and follow the parameters of those rules. So I can't predict at this point, but certainly, Russia has a valid jurisdictional issue. And they're going to rule on it and move forward or not.
Okay. What was the jurisdictional issue? How do they have a valid jurisdictional point in this case? Well,
again, Russia can claim, I think, various. They can look at the definition of jurisdiction within the ICJ and to outline why they do not have the jurisdictional issues related to consent, related to the claim lacks merit, et cetera, that the judges would consider related to that issue.
Is the ICJ, is it politicized? We had a professor on from the University of Miami Law, my alma mater. She said that the ICJ is politicized compared to other courts in The Hague. Is that true?
Well, I'm not going to say that, because what that is that's a direct attack on the legitimacy of the world's court on these issues. Obviously, the judges are appointed, nominated by their member states of their countries, but I wouldn't go so far as say they're politicized.
You were saying the ICJ is not politicized. Could you explain your answer again?
Certainly. Again, Alex, it's a good question, and I wouldn't say that they are politicized. I just still think that that's an appropriate characterization. These are learned judges nominated by their member state countries to be on the world's court, and I think that in the vast majority of the situations, there's not politics involved. So I would be very careful in saying that they're politicized. You know, certainly each party has their emotions, each party has their positions, and so parties may or may not feel that decisions made by the world's court, the ICJ, is political or not. That's a matter of opinion, but I wouldn't go so far as to say broadly and as a matter of fact that they're politicized.
What do you think the decision of the court's going to be after this immediate hearing?
Well, again, I don't know. It's up to them to decide. I think that the claim by the Ukraine lacks great merit, but it'll be up to the judges to decide whether there's jurisdiction to move forward. But I think that Ukraine has a very valid claim.
Well, you said that they lack merit. Is that correct, or they do have merit, the Ukrainian side?
They do have merit.
Okay.
I certainly hope I didn't say lack merit. No,
Okay.
not at all. There's merit to their claim.
So then what happens after this? They make their decision. What happens after that? Obviously it's difficult for them to enforce the decision.
Well, again, it sets a political point for diplomats and others to use as a cornerstone for further political decisions and actions related to the decision. Yes, unfortunately, the ICJ doesn't have enforcement capability, but it's always politically embarrassing for a country to ignore a valid decision by the world's court, and it puts great pressure on them practically, legally, and diplomatically to adhere to the decision.
At what point is there going to be a trial to determine if Russia is guilty of violating these conventions?
Well, again, that'll be set by the court using their procedure, assuming all of the jurisdictional issues are taken care of. But I can't speculate when they would, but certainly, within this coming year.
So ICJ, they can't enforce the decision, but if a country chooses to ignore it, it would be an embarrassment, and other countries could sanction them diplomatically, financially, if they choose to ignore the decision of the ICJ?
Well, I'm not saying that there'd be sanctions. It'd certainly be grounds for a losing party to ignore a decision by the ICJ. It could lead to further practical, political, legal, and diplomatic efforts to ensure that they comply with the law. I mean, any member state of the United Nations which refuse to comply or ignore a decision by a UN entity such as the ICJ, certainly will suffer consequences, to be sure.
My final question, do you have any final comments about this case? Is there anything about this case that caught your attention that you'd like to say?
Well, one thing I think it's important for your listeners to understand, and that is that I'm always for countries going to appropriate United Nations or world bodies to resolve their disputes peacefully and not resort to force, which is the fundamental principles of the United Nations, is we do settle our disputes peacefully and do not resort to force only as a last resort, as opposed to picking up an AK-47 and resolving their disputes this way. So this is a positive step, regardless of the outcome.
Well, thank you so much for joining us today, Professor Crane. Really appreciate it.
No, thank you so much, and sorry about the technicality issues.
No problem. Thank you so much. Really appreciate it. Have a good day.
You too.
I'm Alex Gupta with UATV. That was Professor David Crane, Professor of International Law at Syracuse Law School in New York.